Thank you for joining us. To our alumni, thanks especially for your ongoing engagement with our law school, and I extend a special welcome to the members of the media here today. Well, for all of you joining us, I hope that you and your friends are healthy and safe at this time. I regret, of course, that we're not able to do this in person as we have traditionally done, but I'm very happy to report that the University of Chicago and the law school are in process to resuming regular in-person activities right here on campus. Just outside my office, our orientation programs are well underway. This past week, we welcomed the JD class of 2024 and the LLM class of 2022 to the law school. And we're also holding a special program for our returning 2Ls, some of whom had only limited campus experience last year, to a reorientation to fully welcome them to our law school. And we look forward to next Monday when our new academic year will officially begin. We're proud of what we accomplished last year with our mix of hybrid and remote teaching, and we're delighted to welcome our students and faculty and staff back to Hyde Park for full on-campus instruction this year. I'm enormously grateful to our dedicated and hardworking faculty. They've delivered a transformative educational experience for our students, the experience our law school is known for, in multiple formats over the past 18 months, and their commitment to teaching excellence has allowed our intellectual community to thrive despite our physical distance. And throughout the pandemic, our faculty has continued the scholarly eminence of the law school. Our faculty continue to develop and share path-breaking ideas in law. And I'm delighted that today we have the opportunity to convene a panel of our faculty to share their ideas with you as we begin the new Supreme Court term. So I'm delighted to introduce our faculty speakers for today, Professors Bridget Fahey, Farah Peterson, and David Strauss. Their accomplishments are so many, I could spend the entire hour on this, but I won't. I will give a brief introduction of each one, and then we'll go directly into our program. Now, I don't need to remind our alums that learning at the University of Chicago is famously participatory. So we will leave time for questions. Please submit your questions at any point in the program through the Q&A function. So let me introduce our faculty today. Bridget Fahey joined the law school last fall as an assistant professor of law. She teaches constitutional law and contract law. Her research focuses on the theory and practice of American federalism, especially forms of intergovernmental interaction, joint lawmaking, and collaborative governance that challenge traditional paradigms of federal-state interaction. Professor Fahey holds a law degree from Yale and her undergraduate degree from the University of Chicago. Before returning to the faculty, she was a litigator in Washington, D.C. at WilmerHale and a law clerk on the D.C. Circuit and a clerk for Justice Sonia Sotomayor. Professor Farah Peterson is professor of law and a legal historian who focuses on statutory interpretation. Professor Peterson holds a PhD in American history from Princeton University. She earned her law degree and bachelor's both from Yale, and Professor Peterson clerked for Judge Guido Calabrese on the U.S. Court of Appeals for the Second Circuit and for Associate Justice Stephen Breyer on the U.S. Supreme Court. She's currently at work on a book about the history of judicial interpretation. David Strauss is the Gerald Ratner Distinguished Service Professor of Law and the faculty director of the Jenner and Block Supreme Court and Appellate Clinic at the University of Chicago Law School. Professor Strauss has argued 19 cases before the U.S. Supreme Court. He is the author of some of the most influential articles in constitutional law and interpretation. He has many accolades, including he is a fellow of the American Academy of Arts and Sciences. Professor Strauss is the teacher that every member of our faculty aspires to be. In addition to his current teaching interests, constitutional law, federal jurisdiction, administrative law, and our marquee University of Chicago course, Elements of the Law, he's taught civil procedure and torts. He has received our Graduating Students Award for Teaching Excellence numerous times, including most recently this past year in June 2021. So now on to today's program. The title of our presentation is Supreme Court Preview 2021, Highlights and Perspectives. Again, our panelists will give a preview and then we'll open the floor to questions. Please submit your questions anytime through the Q&A function. And now I turn the program over to Professor Bridget Fahey.
Thank you, Tom. And thank you to everybody who's joining us. Of course, it would have been fun to be able to do this event in person, but I hope that we can have a fun conversation. And with Farah and David on the panel, I know that we will even over Zoom. So I know that my colleagues are going to talk a little bit about the blockbuster merits cases that we have coming up this term. So I wanted to use my introductory time to talk about the part of the court's caseload that has traditionally gotten less attention, but has really sort of claimed the spotlight in the last year and several years before that. And that's what our colleague Will Bode has kind of memorably called the shadow docket. These are the cases that the court decides outside of the standard merits process. So beyond those 70 cases that the court considers slowly and deliberately throughout the year, there are lots of ways that the court takes formal action. And some of those were the most significant and headline-grabbing cases of the last year, and we're already starting to see some of those shadow docket cases populate a kind of list of most significant actions for this upcoming term, even before it's formally started. So for those who aren't familiar with the shadow docket, it includes things like requests for emergency relief in civil cases. So last term, those requests were dominated by the COVID-related stay-at-home orders. But it also it's increasingly common for challengers of federal, state, and local action related to a wide range of policies, from elections to climate change, immigration, and the like, to seek emergency relief. And with the expansion of nationwide injunctions issued often by district courts, these requests in turn have increasingly made their way to the Supreme Court. The shadow docket also includes requests for emergency stays in criminal cases, most importantly in the death penalty context, in which just about every execution is preceded by a request for an emergency stay at the court. And just recently, the court granted one of those requests. They're quite rare, but they do happen. And the shadow docket also includes even more mundane things like summary dispositions, through which the court kind of exercises a managerial function over lower courts, and GVRs, through which the court sends cases that it's holding in light of other merits cases back to lower courts for reconsideration in light of newly announced legal rules. So the shadow docket, as Will's sort of now accepted name suggests, is not uncontroversial. These are actions that take place without the deliberative process and without the level of explanation that the court generally accords to its merits decisions. And because of the hurried process that attends these orders, there's real ambiguity, even among lower courts who write about this question in formal ways, about whether these opinions are binding, whether the reasoning articulated in the often unsigned per curiam orders that are set forth in the shadow docket, or even the concurrences in those dockets, as came up in the recent debates over the eviction moratorium, should be binding on lower courts and on governmental officials. So there are really predictable concerns about transparency and reason giving, and the thought that the shadow docket creates a space kind of ripe for opportunism and for political influence. So I wanted to just think about what the shadow term for OT 21 holds, and I'm going to cheat a little bit and look a couple of weeks backwards, even though this event is generally about prediction, because the shadow docket in its informality knows no first Monday. And I think most people would agree that it already kicked off 2 weeks ago when the court let a Texas law known as SB 8, which effectively bans abortions after 6 weeks, go into effect by declining to issue an emergency stay as part of its docket. So Texas enacted SB 8 late last spring, and the text of the act pretty explicitly admits that it violates the legal frameworks for abortion rights articulated in Roe and in Planned Parenthood versus Casey. So the law is the kind of law that would ordinarily be well suited to an emergency injunction to preserve the pre-law status quo while litigation over the law is pending. And indeed, the district court enjoined the law in that case, but the Fifth Circuit withdrew the injunction, and in a short 5-justice per curiam order, the Supreme Court declined to reinstate it. So the law is now in effect. So I wanted to talk about SB 8, both because it's been in the news and I'm sure is on the minds of a lot of people in the audience, but also because it's a really probing window into, I think, where the shadow docket sits today and what we might expect in the year to come in this part of the court's caseload. So the law, like I said, really overtly invites a constitutional challenge on the substance. It's really betting that there's a majority on the newly populated court to overturn Roe. But the law is mostly about process. It uses several innovative procedural techniques to really specifically script out how and whether it can be constitutionally challenged. And when the case made it to the court in early September, the 5 justices who declined to issue a stay followed the script that the drafters of SB 8 had written almost to a T. The 5-justice majority cited the very procedural novelties designed to insulate the law from constitutional scrutiny as a justification for declining to stay it. So the court said, look, we can't conclude that the challengers have a likelihood of success on the merits, however much the law contravenes Roe and Casey, because we just can't tell whether they're going to be able to overcome the law's novel procedural arrangements. So I think the first remarkable thing about this opening opinion of the 2021 shadow term is that the Texas drafters of the law, they really had the court's number. They anticipated that including procedural complexity in the law would give the court justification for letting it go into effect without having to say a word about Roe or Casey. This suggests to me that the parties who know that they'll end up before the court are drafting laws and policies with an eye not just to the merits docket, but with an eye specifically to the shadow docket. So in a related context, Texas law professor Steve Vladeck has documented something similar in the federal government's interactions with the court over the last presidential administration. So he documented a steep increase in the number of stay requests made by the Solicitor General's office. And although the court didn't play ball in every case, it did in a lot. So I think what we're seeing across a range of contexts is a kind of new dance that has emerged in the shadow docket between select litigants and select members of the court, in which those crafting and challenging policy are very much cognizant in pretty fine-grained ways of what the court needs in this distinctive context. So the second thing that I just want to note about this case is the sharp words, especially in the dissents to the court's order, about the shadow docket itself. So this case is notable because Justice Kagan, in her separate dissent, critiqued the shadow docket by name, which I think is Will would know better than I, but I believe is the first time that a justice has ever used the phrase shadow docket in an opinion issued by the court. And she, she said really strongly that the shadow docket was becoming more unreasoned and inconsistent and impossible to defend every day. So if one complaint about the shadow docket is that it lacks full transparency, the best way to bring that transparency is to think about some changes in the court's norms and procedures that can get the cases that go into the shadow docket more robust airing of the substantive issues. But a second best, perhaps, is having the justices really press a critical conversation about the shadow docket into public view themselves, and that's what Justice Kagan started to do in her dissent in the SB 8 case. So the last thing that I would just want to note about this case is that, a lot of people who watch the court are especially keen watchers of the Chief Justice, and I think the Chief's behavior in the shadow docket cases over the last year and in the SBA case are worthy of note. So of course the court, in everything it does, blends formal process and informal norm. So it's not surprising that we would see some of the kind of convulsive forces of the last few years, the dramatic change in court personnel, the contestation surrounding the election, the global pandemic, influence more quickly the parts of the court's operations that are more norm-based, like the shadow docket. And I think you can see the chief in his dissent in the SB8 case cognizant of that and really trying to reclaim a kind of institutional center. Now we can have a conversation about whether that's likely to succeed, but you see Justice Kagan and Justice Breyer joining him in that project. It suggests kind of increased cognizance by the chief and others about what's going on in the shadow docket. So we have lots more in store for the shadow docket over the coming year. I think we can consider a challenge to the OSHA vaccine mandate that President Biden announced last week as effectively calendared to the shadow docket for a few weeks from now. OSHA is going to issue those emergency regulations. Lots of states have said that they're going to challenge them. And of course, one district court can sustain those regulations, but it also only takes one other district court to issue a nationwide injunction and kind of force the issue to the Supreme Court's door. So we can expect that on the shadow docket to come. There are several states who are in the process of trying to pass laws like SB8. So we could see another one of those cases come before the court. And of course, this is the year after a census year. So every state is redrawing its district maps, and those are cases that traditionally have occupied the shadow docket. So the last thing I'll say before turning the floor over to Farah is that one thought about the shadow docket is that the court could be a little bit more creative about how it handles these cases. We really have this kind of binary between the full bore procedure of the merits docket and this kind of fast anything goes ad hocery of the shadow docket. And of course, the court conducted telephonic oral argument throughout this entire past year. So it could easily schedule fast telephonic for the cases on the emergency docket to just increase the transparency and the airing of the substantive issues. It could sign the orders instead of issuing per curiams. And it could take more of the cases on the shadow docket and put them into an expedited posture on the merits docket. I'm sure there are lots of other thoughts, but as we've seen over the last year in the court's adaptation to COVID, the court can be more procedurally creative than I think it has been willing to be so far. So I'll stop there and turn the floor over to my colleagues.
So I just want to pick up on something that Bridget just said. Bridget and I spend a lot of time chatting together, so it's not unusual for me to pick up where she left off. One thing that occurs to me about the shadow docket and begins the theme that I want to talk about is one of the things that the justices are really focusing on, and you heard it in Associate Justice Barrett's speech in Louisville this last weekend, and in many of the speeches Associate Justice Breyer has been giving in connection with his new book, is the theme that they're concerned that the court is starting to look partisan, and they want to reassure the public that there's a legitimacy to their decisions. It's not just based on who appointed the justices, whether they were appointed by Republicans or Democrats. And one thing that is concerning for court watchers like us about the shadow docket is the nature of the decision-making that happens, especially about these substantive issues, looks more like the political branch's decision-making than it looks like the decision-making of the Supreme Court. Usually when a substantive issue comes to the Supreme Court's attention, they put off making any law about it until multiple other decision makers have had a chance to weigh in, until many other courts have weighed in, until many other brains, smart brains, peers on lower courts, state experience has developed on these issues, so that they are not the icebreakers on an important issue of law. And instead, we see in many very important, very politically charged issues, the Supreme Court charging ahead to make politically charged decisions, in ways that suggest an exigency that don't always seem merited by the circumstance. And that's something to watch because it suggests a change in habits that might last beyond the particular edges. For some reason, I can't say this word today. The particular circumstances of our COVID year and all the other emergencies that have emerged over the last couple of years. So that's something to look at. But that's the theme that I wanted to talk about today. I was listening to Justice Barrett's remarks and thinking about how, yes, that is the theme of this coming term. Can the court suggest to the public that a change in personnel does not mean a change in the law, given the blockbuster cases that are lined up for the docket this year? Already we have calendared, or we have scheduled for argument a major abortion case, Dobbs v. Jackson Women's Health, which deals with the Mississippi's legislation banning any abortion beyond the 15th week of pregnancy. That case was brought by Mississippi's last remaining abortion clinic. And, Mississippi makes no pretense in its brief that this law can stand under the precedents, under the Supreme Court's precedents in Roe v. Wade and Casey. I was actually surprised to see the brief when it came in that the entire brief almost says simply, Roe v. Wade should be overturned and it has no precedential value whatsoever. It's only at the very end of the brief that Mississippi says, if the court decides not to overturn Roe, at least overturn the viability line that the court has upheld in previous cases. So this is really throwing down the gauntlet and asking the court to finally do what states around the country who have legislatures hostile to women's right to choose have been waiting and hoping that this new change in personnel would mean for the right to life movement. So this is not a court that has the opportunity to sort of inch forward and tiptoe around issues the way perhaps the Chief Justice would have liked. And we saw an early shot across the bow on that issue in the SB 8 midnight decision. So that'll be an interesting case to watch. And then, of course, we have the first major gun rights decision on the calendar. That's New York State Rifle Association v. Bruin. Is that the name of the case? New York State Rifle and Pistol Association v. Bruin. Now, it's been 10 years since we last heard a Second Amendment case, and speculation was that perhaps the court wasn't granting cert on Second Amendment cases because the conservatives were not sure how Justice Kennedy or Chief Justice Roberts would rule. Well, now there are new members of the court, and for the first time, there are 4 votes to grant to resolve what the conservatives see as a split of authority on the right to carry guns outside the home. And this is going to be a very, very interesting case. As a historian of early America, I find these cases particularly interesting because the briefs are very heavy on originalist argument. I'm not an originalist myself, but I opened the brief for the New York State Rifle and Pistol Association, and I see that almost the first half of it is entirely, 18th century and earlier law. This is interesting for a few reasons. First of all, the history is not necessarily a slam dunk for the proponents of expansion of the Second Amendment right. You see constant quotes throughout the text from St. George Tucker and early, Associate Justice James Wilson to the effect that the founders were, of course, in favor of carrying guns so long as they were not unusual and dangerous. Well, what would an 18th century person have thought of a modern handgun? Would he have thought that was dangerous? Seems at least like an interesting question, a valid question. And then, of course, there's the larger point that the founders never considered the kinds of technology that we have today. The kinds of technology, a rifle at the time of the founding could shoot maybe 3 rounds per minute. they never considered the kind of gun that we have today, that a rifle that can shoot dozens of rounds per minute and is turned on a classroom full of children. And we can't know what a brain like Madison's would have come up with if it had been turned to this kind of problem. So, you know, a historian looking at these briefs, as a historian looking at these briefs, I find them very interesting, and I'll be watching these cases very closely. And, you know, we should all be watching these cases very closely, because the larger issue is suddenly the court has new members who are newly interested in taking up issues of grave public concern. And for all that Justice Breyer and Justice Barrett insist that the court is not partisan and point to the majority of cases on which, in fact, judges appointed by Republicans and Democrats agree. The cases that the public pays attention to, that the voting public pays attention to, are cases on which they are sharply divided. And so the court's legitimacy rests on being able to show the public that a change in personnel does not mean a dramatic change of law in those cases. And that's what's going to be at stake in this term. And so that's what we're going to be watching. Now I've lost track of time, so I'll just briefly mention that there's another very interesting historical moment that may come up this term, which is we're at the end of, I shouldn't say the end, because who knows what the future holds, but we're at a turning point in the 9/11 era. And we have already calendared two cases that deal with the confrontation between the sort of openness and candor that our system of judging and due process requires, and the secrecy that national security demands. In the October sitting already, we have the case involving the Guantanamo detainee, Zubaydah, the Palestinian, who was long thought to be a member of Al-Qaeda, but now doubt has been cast on that, who was tortured in a black site in Poland, I should say allegedly, but the president of Poland has acknowledged it, and who now, after a favorable ruling by the European Court of Human Rights, filed suit, a civil discovery suit in district court in the Ninth Circuit, asking for discovery from the two psychologists who worked for the CIA to develop his torture program in aid to a prosecution in Poland connected to his torture. The Ninth Circuit ordered the district court to look into whether any part of that evidence could be separated out to save it from the state secrets doctrine. And the Trump administration asked the Supreme Court to say, no, the entire thing is covered by state secrets. And so we have a confrontation in this case between the openness and secrecy, sort of major principles that have so corrosively confronted one another during this entire era of our sort of modern American history. There's another case in the November calendar, Fazaga, which deals with domestic surveillance of 3 Muslim Americans by the FBI under a domestic counterterrorism operation that deals with similar broad themes, and also a petition to watch that has not yet been granted by the ACLU, dealing with whether Americans can get any information on the substantive rulings of the FISA court, the foreign, help me out, David, I'm having a brain freeze.
Foreign Intelligence Surveillance Act.
Thank you, David. And, this is the kind of issue that cannot develop a split, but it is an issue of great national importance. And one would hope that we're at a point in the sort of maturity of our national conversation on these issues of national security, and yet the importance of candor and due process, that maybe there could be some movement in opening up some of the secrecy to public view. So I'm going to turn it over to David at this point. Thank you, David, for the save.
Thanks, Farah. Thank you, Tom, for the introduction, and thanks to all of you for being here the best we can do very often these days, but thank you for coming to listen to us. Most of what I have to say, a lot of what I have to say is going to follow up on what Bridget and Farah said, not surprisingly, because I've learned a lot from them, even in their sort of relatively short time on our faculty. Let me sort of highlight a short-term and a long-term sort of thing to watch at the court. The short-term thing is this the term in which the culture wars return to the Supreme Court in a dramatic way? And then one long-term observation I have about the consequences of the era of really congressional paralysis that we're living through. So on the culture wars issue, I mean, Farah and Bridget mentioned the Dobbs, the Mississippi abortion case, and the New York State concealed carry case that the court took. In both instances, there were reasons to think maybe they wouldn't take the case. Dobbs, they relisted, which is to say, thought over whether to take the case or not repeatedly before they finally took it. And as Farah said, the court had been passing up opportunities to get back into Second Amendment issues. There was one quirky Massachusetts case and one earlier case from New York City that New York City mooted over the objections of some of the justices. But by and large, the court's been avoiding Second Amendment issues since McDonald against City of Chicago, the case that said the Second Amendment applies to state and local governments. So the fact that they took the case is a significant signal. It's hard to see it otherwise. And the other two possible culture wars issues that we might see, one is affirmative action, the Harvard case challenging Harvard's admissions policies. There's a petition pending. The court's asked to use the Solicitor General. Solicitor General hasn't yet given her views, and the acting Solicitor General. My guess is that the SG will provide the court with the office's views in time for the court to grant and hear the case this term if it so decides. I don't have any real sense of whether that's an issue the court's going to want to get into. The case is quite complicated in a lot of ways. It's not obviously the case you would take even if you wanted to change the law on affirmative action, but it's a real possibility. And the other issue is religion, which really seems to be a preoccupation of the court, as we saw in some of the COVID cases where the court used the shadow docket to make new law on freedom of religion. It wasn't fully explicit about that, but I think that's a fair statement. And the idea that religious belief is not taken seriously by a lot of elected officials, that seems to be an idea that's held by many members of the court. So I wouldn't be surprised to see religious exercise issues return at some point in some form, either fully granted cases or maybe, more likely on the shadow docket this term. So that, I think, is a possibility, a real concern for reasons Farah said, at least among members of the court, members of the public who think the court is acting too much like a political branch of the government. These are the issues that are most likely to prompt that reaction. Just by way of contrast, Farah mentioned the state secrets cases, which are interesting and really important cases. It's great that she mentioned them and gave us such insight into them. Those are important cases. It's not clear those will break down on the usual lines. They're tough issues. The state secrets privilege is one of those things that's been around for a long time. It really seems awfully broad. The court hasn't returned to the subject recently, and it's obviously important. So, maybe that will be a counterexample to my culture wars theme, as something that really kind of bridges a divide and gets the court into the frame of mind of here's a genuine problem in the way that Farah outlined that we have to grapple with. Let me say a word in connection with the culture wars about SB 8, the Texas statute governing abortion. I guess it's two reactions. One is there's been a lot of talk about the novelty and ingenuity of the Texas statute. It is certainly ingenious in a lot of ways and novel in some ways, but we've kind of seen this before. Here's where we saw it before. I'll say what the this is in a second. During the Civil Rights era, before the Civil Rights Act of 1964 was passed, essentially only government racial discrimination was unlawful. Private racial discrimination was not. So what you saw in a lot of segregationist states was efforts to present discrimination that was obviously backed by the government as a private matter. And sometimes this was just the way the system worked out, that the issues came up in private litigation. Sometimes it was the product of very deliberate contrivances to make something look private, even though it really wasn't. For example, the Texas Democratic Party, which dominated politics in Texas at the time, reconstituted itself as the Jaybird Club, and then said, well, we're a club, we get to admit whoever we want, we choose not to admit any Black people. So it's just private action. So there were things like that that were, people thought of this general move of let's privatize things that the government could not do itself. Now, if you want to say, look, the difference is racial discrimination really is unconstitutional, there is no right to an abortion in the Constitution, and that's the difference. If you want to say that, okay, that is a coherent position. But it seems to me it's very difficult to justify what the Supreme Court did in its Shadow Docket SB 8 case without taking that position, without saying Roe against Wade is simply no longer good law. There is no constitutional right to an abortion. That's why we're not granting emergency relief. I don't agree with that, but I get that. But that would be an extraordinary thing to do in a summary proceeding, to say this precedent of 50 years standing is now overruled without briefing, without argument, without amicus briefs, et cetera, without full deliberation. Now, that would be truly extraordinary. And failing, if that's not the premise of the decision, it seems to me very hard to explain why the balance of equities tips against allowing people to continue to exercise what is by hypothesis a constitutional right, and in favor of some very sort of technical sovereign immunity based objections to what the abortion clinics were asking for. Okay, that's the short-term theme, as I said, is whether culture wars return to the Supreme Court. They are certainly teed up, but whether the court will continue down that path, or come up with narrow rulings. They've surprised us before in their ability to duck issues that they seem to be prepared to tackle. But I guess I would not be surprised to see, as I said, this be the term in which at least, abortion, gun rights, and religion really occupy a lot of attention, and possibly affirmative action as well. Now, my long-term idea. This is not original with me. I first heard it from Adrian Vermeule at Harvard, and Jody Freeman has an article on basically the same theme. But here's the idea that increasingly the big issues before the Supreme Court will concern not constitutional law, but administrative law. Now, that sounds like just a bit of academic turf stuff. Here's the course I'd like to teach, Dean Miles. But it really gets at something fundamental that's happened to our system. And the fundamental thing that's happened, as I mentioned at the beginning, is Congress seems to be unable to pass substantial new legislation on important subjects. So when new problems arise, what happens is the executive branch has to take what statutes are out there, often passed to deal with different problems, and apply them to new problems that they were not intended to address. Now, very often there's language in these statutes that can be used to address these new problems, and that's the hook that federal administrative agencies hang on when they want to address these problems. The COVID vaccine is an example of that. OSHA, if you ask sort of just a casual person familiar with OSHA what it's about, well, it's about workplace hazards like unsafe drill presses or ambient environmental hazards in the air, cotton dust or methane in the air. It's not about a pandemic, but maybe the language can be used that way. And because there is no comprehensive legislative response, the government is in the executive branch in the position of using that language. We actually have seen this pattern a lot. So the Clean Air Act is being used to address climate change. The language allows that, but that's not what the act is really about. Telecommunication statutes in the 1990s are being used to deal with internet issues that were barely in the picture back then. Bridget actually has a paper on privacy protection that sounds some of these same themes, that what we need, ideally, I mean, I'm filling in the blanks. I'm not sure Bridget would endorse this, but one thing I took away from her great paper was we really need a comprehensive federal regime. We don't have that, so instead we have a lot of ad hocery at the state and local level. So this is a recurring pattern. I expect to see it return, that we'll see increasingly aggressive efforts to use statutes by administrative agencies in ways that they kind of weren't intended for, but the language allows it, and that will force these cases to the court very often, as Bridget said, on a shadow docket, because there'll be quick lawsuits. And it's a tough problem. It's not, there's no, it's not obvious what the sort of attitude the court should take. It's possible the court should say, no, this is a problem for Congress. Until Congress acts, we will not let the executive branch act. It's also possible the court will say more realistically, you know what? We really are in an era where we're not going to get congressional action. As long as what the government executive branch is doing is not clearly unlawful, we're going to allow it to go ahead. I would expect that to be a real theme beginning this term. It has already happened to a significant degree, as I said, beginning this term. But in the long run, I would expect to see that coming up more and more. And with that, let me turn the program back to Dean Miles. Tom.
Thank you, Bridget, Farah, and David, for a really fascinating and illuminating set of remarks about the upcoming term. As you can imagine, your remarks have generated a whole set of questions that have been pouring in, and I thank all of our participants for sending in your questions. Please keep sending them in. I'm going to exercise the sort of the chair's prerogative to try to organize them so that we can get through as many of them as we possibly can in the time that we have. And so, here I'll highlight some of the themes or some of the topics of the questions that have come in, so we kind of know what might be coming in the conversation. A bunch of questions following up on the discussion of SB 8, a bunch of questions more about the shadow docket, several questions about what I would describe as politics and law, and Professor Peterson's remarks about that, as well as sort of broader questions about that. And then I would say two categories of questions that pertain to COVID and the pandemic. Some of these are about the operation of the court, and some of these are about the substantive law that may emerge from the pandemic. Then also questions about voting rights, and then also some questions just about the future and nature of the court generally. So why don't I again just pick a spot for us to parachute into these questions. And let me start with this one that relates to COVID. It seems timely since we're doing this in remote format, and I think so many people are going back to the office for the first time or contemplating going back to the office. The Supreme Court announced, I believe last week, that it is going to return to in-person oral arguments next month. Do you think it's important that oral arguments happen in person rather than in remote format? Do you think it affects the court's decision-making and the court's interactions? And then I would append to this a separate question that has come in, which I think is a perennial one, which is about whether the court should allow cameras in the courtroom. So any thoughts on any of that? I think a lot of us have had conversations, especially at universities, about whether the nature of our teaching or the nature of our interactions as scholars are different when we are in remote format rather than in person. Is there a parallel for the court's discussion of cases and oral arguments, its deliberations? I open it up to the panel for your reactions to that, and then I'll follow up with some questions about some areas of law that might be related to COVID.
I do think that there is some importance to in-person oral argument. Now, I'll caveat that I don't think that importance is such that it is worth even one person's life or health. So, this is not to say that I think that opening it up during COVID is the right decision. I don't know. I'm not an epidemiologist. But I think that the theater of having court in person is important. It's important in the same way that judges wearing robes is important and having courthouses is important. It's important because it impresses the litigants and their lawyers and the audience of the public with the impression that what's happening there is not just other individuals making decisions based on a layperson's judgment about right and wrong, but rather a court applying reasoned judgment based on precedent to the facts arising before it in a way that will last longer than the individual case and that is based on something that precedes the case before it. It's a pomp and circumstance with a purpose. So I think the in-person nature of it plays a role in the legitimacy of the institution. And I think it plays a role that is special in a way that even the sort of pomp of the other branches of government may not. The court is a theater in a way that is intrinsic to its legitimacy. For the same reason, I would hesitate to put it on TV, because I think that the in-person nature of it and the special quality of being able to see it only in one place and only under certain circumstances, like being able to see only one run of a Broadway show, heightens the special nature of that experience and confirms its power. And to make it too available, while it has some benefits, also has some important drawbacks. And it is already available enough to have democratic reach because we can hear the oral arguments 3 days after they're offered. Everybody can listen to everything that's said. There are transcripts. There's not an access issue. And so then the question is, what is added by adding cameras? There might be a certain sort of tawdry celebrity factor that is added into the experience for the justices or for the litigants or their lawyers that brings down the special sort of hallowed quality of the arguments in a way that might take away from the theater of the court as it exists now. So that's my opinion.
Thank you, Farah, for those remarks. Bridget, do you want to weigh in? David, do you want to weigh in, or shall I go to the next question?
I mean, the only thing that I would add is that, oral argument is just one of the many things that the justices do in person together. And I think probably nobody on this call, maybe some members of the audience who were clerking on the court over the last year would know the answer to this question about how the justices interacted with one another while they were doing completely remote oral argument. And when you get new personnel on the court and so many new members in such a short period of time, and such a fast-moving docket on the shadow docket and so many high-profile merits cases, being able for the clerks to interact with one another and the justices to interact with one another in person strikes me as probably important. My suspicion is that they will not be milling around the court and kind of freely, having lunch, and they're probably unventilated room, even though they're returning to in-person oral arguments. But I would hope for the kind of I would hope that they would be able to get back to in-person operations safely, as would we all like to be back safely to in-person operations. But I think what happens outside of the oral argument chamber is probably as important, and I think probably more important than what happens within it.
Yeah, the only thing it's really just an elaboration on what Bridget said. When I saw some of the sharp language in the opinions that have been written over the last year, I wondered whether things would have been quite that harsh if they were seeing each other on a regular basis. It's just a little bit tougher. I put it the other way, it's a little bit easier to be nasty, as we all know, a little bit easier to be nastier to someone you don't have to see face to face. And so the sort of really just what Bridget said, that the extent of contact among them might matter as much, if not more than having oral arguments in person.
Thank you for that. So let me turn to a set of kind of Constellation questions that have come in sort of related to some COVID issues. So I'll group them a little bit here. We've seen the court handle a number of cases that have been presented because of the circumstance of the pandemic, the eviction moratorium, the Indiana University vaccine requirements, perhaps other issues will come up. David mentioned OSHA. There's also litigation of mask requirements going on in Florida that, who knows, will these reach the court? One way to group these is to ask, will the experience of the pandemic have a lasting influence on the substance of our law? Will there be a field pandemic law? A specific question also has come in about the Indiana case, and that was where the court refused to enjoin the University of Indiana from requiring students to receive the vaccine as a condition of admission to the university. And the question is whether that ruling involved a determination that such a requirement is constitutional, and if not, is the ruling a clue about the court's view on the constitutionality of mandatory vaccines? So anything that kind of a broad set of questions there about issues related to the pandemic and whether or not, are these all one-offs, or are these going to be a theme or a coherent body of law, or are they collectively going to be something that influences and shapes other law or rights generally? So anyone want to tackle that kind of constellation of questions that has come in?
I can comment on the Indiana decision, at least to say, I think it was obviously the correct decision. Justice Barrett denied the request for an injunction without referring that request to the court. But the reason is that case didn't raise kind of colorable constitutional questions. I mean, it asserted a constitutional right to medical treatment of your choice and bodily integrity in a kind of half-hearted way. I think, it will be interesting in thinking about David's comments to see, I would expect that the seriousness with which the OSHA vaccine mandate will be challenged will be dramatically higher. And that case won't be about an asserted constitutional right to bodily integrity, although you might see some kind of constitutional backgrounding principles, about general freedoms to access medical care, but will be about the text of OSHA, the statutes that authorize OSHA to regulate workplaces. And so it'll be an example of what David was talking about administrative law being the battlefield on which these fights are being fought. And, I do think we could see a more serious case about vaccine mandates in a constitutional register. It does create kind of interesting bedfellows. You don't frequently see in the sectors of the legal world that oppose vaccines arguments trying to strengthen a person's right to bodily integrity, as we know from the abortion cases before the court right now. So it's a little bit of a, who would be the plaintiffs in these cases, and who will be the legal brain trust behind these kinds of claims, and will they be worried about undermining the anti-abortion cases that are working their way through the court at the same time, I think is a kind of interesting question about those constitutional claims. I don't think anyone will have an issue pressing vigorously the administrative version of these claims once the vaccine mandate comes out.
I don't think I have much to add. The question Tom posed reminded me of a conversation I had with a law review editor who was in charge of screening articles for publication. And she'd been doing the job for the last year. She said, we have gotten 100 million articles with the title ... in the time of COVID. So that's at least where the academic world is. One way into this question, I don't have a response to it really, but one way into it is to think about previous crises and whether they had lasting effects on the law. Because we've seen, not only the influenza pandemic, but the wars we've been involved in really have to rank in the same category. And to sort of ask the question, well, did they produce lasting changes in the law or just transitory, if any, changes. My very, very offhand impression would be that sometimes they produce lasting changes. Sometimes they produce lasting changes in the opposite direction, that there were wartime abuses. And then when things calmed down, people said, let's not do that again. The Japanese internment being the clearest example, but also the suppression of speech during World War I would be a sort of a prominent example. But it depends on not so much what happens in the time of COVID, but how the fabric of the law develops. And if the fabric of the law develops in a direction that, for example, recognizes extensive administrative authority in the government, people will look back and say, yeah, it was because of COVID. That's why we handed over so much power to administrative agencies, even though that was really just kind of one step in a development. Or in the other direction, if the idea is the administrative state has gotten out of control and we need to sort of insist that Congress do things or they not be done, then again, sort of we could see this year as a turning point. But I guess my sort of instinctive reaction is people will overstate the extent to which this crisis made a difference as opposed to secular developments in the law determined either by underlying forces in society or by the composition of the Supreme Court.
Great, thank you. Let me move on to another set of questions that I'm putting under the category of law and politics. And partly I'm putting that under the category of law and politics in that one of the questions that has been posed is simply law and politics. Is there a difference? Is there a difference? Question mark. Which, you know, it sounds like a wonderful sort of essay question we might ask in a seminar. But I'll try to be a little bit more specific about it. And some of the other questions that have come in are a little bit more specific. One question is whether from a historical perspective, is the current division that's observed on the Supreme Court today singularly unique, or is this history just repeating itself? And then I'll add one other question that came in that I think it maybe is related, but feel free to reject it if you view it as not kind of within this category of question. And that is that over the history of the court, individual justices have sometimes been thought to drift away over time from their original judicial philosophy or their original perspectives. Do you think any of the current justices are drifting? And in particular, is Chief Justice Roberts drifting? So anyone want to sort of tackle any of those broader questions about the court?
I'm going to answer the second question because I don't remember the first one. I have this bad habit. I start thinking about the second question and then the first question just sort of fades away. I think that the burdens of governance change everybody, and that, you know, that the experience of seeing the actual effects of rulings that the court makes should and do change any intellectual who cares about the United States and is awake and watching the impact of what the court does. And a person in a position to change his mind should change his mind over time. And I think that the Chief Justice is, you know, one of those intelligent intellectuals. So, you know, we would hope that people on the Supreme Court are capable of changing their minds over time. That's not drift. You know, that should be a precondition of being, you know, fit for the position of Supreme Court Justice. We should not want people who are so fixed in their beliefs in one decade that they are incapable of evolving with changing circumstances and with new information, with the fruits of their experience. And also, we change. What it meant to be a conservative or a Republican when a person was appointed, you know, in the 80s or 90s will be completely different from what it means to be a conservative or Republican in 2010 or 2020 or 2030. So to track exactly what consistency would require would be the task of an intellectual historian. I'm not sure exactly who would be up to that task. But it's not, you know, sort of a casual comment. So yeah, things do change, and that could be a good thing. What was the other question?
The other question was, do you think the current division on the court is singly unique, or is this history repeating itself?
Oh, no, it's not unique. It's not unique. Whenever the presidency changes hands dramatically, the court follows. It follows much more slowly. But the rancor on the court when the long period of republicanism in the early republic in the early 19th century gave way to Jacksonian Democrats. It was very hard for Chief Justice John Marshall toward the end of his career, when all of the precedents that he fought for and everything that he lived for, and all the precedents that we now cite as having been established by him, like Marbury v. Madison, all of the things that you learn about in your first constitutional law class were slowly chipped away by the people who took over that Jackson appointed late in his term. So it's absolutely normal that people with different beliefs are appointed as trends in thought change. And that causes rancor, and people see it as the end of the world. So is the rancor of today and the partisanship we're seeing special? Not especially, I don't think so.
Right. David, I have one question that's specifically directed to you about administrative law. And that is in particular about, do you see the court giving more or less deference to the executive? And in particular, is the Chevron doctrine on shaky ground? I think I remember several years ago, I think at a First Mondays event, we talked about the future of the Chevron doctrine. And so it seems a great occasion to ask updates on what the future of Chevron might be.
Thanks, Tom. I mean, it's no secret that Chevron is under attack. There are some justices, I believe Justice Gorsuch wrote an opinion when he was a lower court judge, specifically questioning Chevron, suggesting it was wrong. And there's a lot of commentary. Chevron, I should say, is the doctrine that, well, it's not wholly clear what it is, but is a doctrine that requires courts to defer to administrative agencies' interpretations of their governing statutes in a wide range of cases. Exactly how wide is a little bit, has always been a little bit unclear, at least in my view. So what is a theme in the writings of some people off the court, and even in several opinions by people on the court, is that the administrative state has gotten out of control. It's doing too much. It's running our lives to a degree that's unacceptable, that these are unelected bureaucrats and they shouldn't have this kind of power. And that has led to calls for cutting back on these doctrines that call for courts to defer to the judgments of administrative agencies. I don't see any reason to think that will abate. I would expect that tendency to continue. That's not something that the new appointees to the court, that I would expect them to disassociate themselves from it. The only thing I'd say is, a lot of times what's going on explicitly doesn't always reflect what's actually going on. And to become more concrete about it, the reason that courts, well, two things really. Number one, a lot of the action here is not at the Supreme Court. A lot of the action is going to be in the lower courts. A lot of administrative actions never make it to the Supreme Court. So it goes on, especially in the DC Circuit and to some extent in the other courts of appeals, really matters, I'd say matters more than what we see from the Supreme Court. The Supreme Court could kind of give instructions and sort of try to change the course. But if lower courts are in the habit of deferring to administrative agencies, that's going to be the key thing. And if they stop deferring, that will be the key thing. And the other is the reason that there are these doctrines of deference to administrative agencies. It's not just sort of parsing the logic of the Administrative Procedure Act. This has very much to do with the Administrative Procedure Act, actually, or even the precedents. It's that it's often a very sensible thing to do. And you're a judge, you're confronted with some very complicated issue having to do with, environmental law or securities regulation or some other branch of the law that's complicated. You don't know that much about it. You have an agency. The agency has explained itself pretty well. They seem to know what they're doing. The instinct to say, I'm going to let them do it is pretty strong. And as long as that instinct is there, I would expect that these efforts to cut back on the power of the administrative state, while they might succeed in some high-profile instances, they might very well succeed in the OSHA vaccine case, for example. that the momentum to defer is going to be, not as strong, but still very much part of our system.
Great. Thank you, David. We're down to just our last few minutes, and I apologize that there are more questions that we did not get to. We had questions on the voting rights cases, which I think we touched on, more questions about the shadow docket, and some of those related to SB 8, more questions on SB 8 itself. But I think we spent some time covering that. So thank you, everybody, for those questions. There is one question that we didn't cover, and I will just ask Professors Peterson and Fahey to address it in a kind of lightning round to give your quick predictions for the future. I'm sorry to do this to you, but this question has come in, and I will excuse Professor Strauss from having to answer this one. This question is to please consult your crystal balls and predict the outcome of future efforts to alter the number of justices or impose other changes on terms of service. And, I will excuse Professor Strauss from answering that because he is on the bipartisan commission. And this is an opportunity for me to also to brag about our colleagues. In addition to Professor Strauss, Professors Allison Croy and Will Bode are also members of that commission. And I think on a proportionate basis, we have more faculty members from our law school on that commission than any other law school, which is wonderful, but I won't put Professor Strauss in an awkward position. I will do the dangerous thing of a dean muzzling a faculty member, but instead I will ask Professors Fahey and Peterson to consult their crystal balls if you are willing to, and offer any predictions about what you think might happen with any changes, potential changes with the structure of the court or with the terms of service of the justices.
Well, we're still in the midst of the process that David and our other colleagues are engaged with. It's my instinct that if we were going to see changes coming out of this effort, it would have to be more of a political priority than it seems to be right now. But we can keep that using statutes, like famously EDPA, courts control how, Congress controls how federal courts exercise their jurisdiction. So there are milder ways of having a conversation with the court about what its scope of authority is and what it can do in certain cases than changing the personnel of the court or imposing term limits or something like that. So I think that that's potentially more likely to see some of these milder efforts, but it's a little bit of a this strikes me as a kind of true question of politics and what the political priorities and results of the elections will be over the coming couple of years.
I agree with that. I think that this is purely a political question. I don't think that it looks like it's worth expending the political capital to change the court right now. But if the court decides to overturn Roe v. Wade, there's another dramatic mass shooting, and the court has recently made it impossible for states to regulate even carrying guns outside the home. And a number of other things happened, or maybe just that. Maybe the political capital will exist. I will say I'm not an expert in politics, but as an expert in law and history, there's no reason to be fastidious about this question as a matter of history. The court has been different sizes over time. It's gone down, it's gone up. There's no reason it can't do so again. So if there's a will, there's certainly a way.
Thank you. Thank you both for responding to that last question. And I really want to thank our whole panel. Professors Fahey, Peterson, and Strauss, thank you so much for joining us today and for sharing your insights with us. As someone mentioned in the chat, the speakers were, not surprisingly, concise, addressing important topics, and enlightening, and I heartily agree with that. Thank you very much. Thanks to our alumni and friends for tuning in. I look forward to seeing you, I hope soon in person, but in the meantime, I hope to see you in more remote events and more remote programming. Please watch for information on that. And I invite our members of the media to please stay on for an opportunity to have some more additional Q&A with our colleagues here. Everyone, please stay safe, stay healthy. I look forward to seeing you all soon. And from Chicago, happy start of the academic year.